Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. On my right and your left is Justice James Milkey. To my left and your right is Justice Marguerite Grant. We will be the panel hearing argument in all 5 of the cases that we have on for argument this morning. Those of you who have been here before know the drill, but I will repeat it just in case. Each side of the V has 15 minutes to argue. If there's more than one attorney arguing on either side of the V, you may divide your time. Please let us know ahead of time how you will be doing so. There is no rebuttal. We're familiar with the arguments that you've made in your brief, the factual and procedural history. We have all of that. You don't need to go through that for us. We will have questions for you, and hopefully our questions will take us beyond what you've already told us in your briefs. If you reach the end of your time before you reach the end of your argument, and the panel has no further questions for you, you may rest on your brief for whatever remains. If you reach the end of your argument before you reach the end of your time, there's no reason for you to continue addressing us. With that, I will call the first case on our list for hearing this morning, case number 2022. I'm sorry, one more thing. We will be taking a brief recess after the argument in the 3rd case on the list this morning and then resume with the remaining 2. The first case on our list for argument is case number 2022 P867, Shoreline Corporation versus Benjamin PENA. This case is partially impounded. I would encourage you just to remember not to refer to any of the impounded materials. Refer to parties by their names if that is the by their role in the case rather than their names if that is the subject of the impoundment. All of our cases, all of our hearings are live streamed and also available for archive viewing on our YouTube channel. So in addition to being public in an open courtroom, they are accessible to the general public over the internet. Okay, you may begin.
Chief Justice, Justices, Leilani Pascal for Benjamin PENA. The Housing Court erred when it entered and then refused to reconsider its judgment against Mr. PENA, an elderly man that a psychologist found exhibited symptoms consistent with Alzheimer's, for running his water on a few occasions. The applicable housing and anti-discrimination laws include multiple safeguards to prevent an eviction like this and keep subsidized tenants in their homes. And I'll focus on 2 of those safeguards here. First, even if Mr. PENA were not disabled, this eviction does not meet the statutory and regulatory requirement that the landlord have good cause to evict from federally subsidized housing. Mr. PENA's volitional act, turning on his water and failing or forgetting to turn it off on a few occasions, is not inherently culpable and therefore does not meet what other courts across the country have found constituted good cause for eviction.
Why doesn't it interfere with the landlord's obligation to provide the other tenants with habitable premises?
It's true that it is a lease violation to run your water in a way that disrupts other tenants and the management. But the question is not whether there is a technical lease violation, but whether it meets the requirements for the termination provision of the lease. And under those requirements, in addition to there being repeated conduct, something happening more than once, you also have, and that be disruptive, you also have to have good cause to evict. Good cause is...
You're making it sound like it's a very benign problem. There was so much condensation inside the apartment that there were 2 inches of ice on the windows.
I'm not going to deny that that caused a problem for management. However, on the one hand, you have this constant condensation, the fact that tenants may have been deprived of hot water on 4 instances for 15 minutes at a time, and not to minimize that, but we've all taken cold showers. I have 2 teenagers. And on the other hand...
This goes, I don't think you're going to get much headway with that comparison because this goes well beyond that. You don't develop the quantity of steam that produces 2 inches of ice on the interior of the windows with a somewhat long shower. This was severe. And let's start from that premise. I want to focus, if I may, on a different prong of your argument that has to do with the grounds in your post-trial motions for relief from the judgment. You rest significantly on, as I understand your argument, on the causal nexus between a psychological cognitive disorder and the conduct that gave rise to the termination. When I see the assertions and the argument in your memoranda to the trial judge and in your brief here on appeal, it seems to describe that nexus in terms that are not substantiated by the psych eval that appears in the record appendix. For example, you make reference, I assume on the basis that we can take judicial notice, although that's not clear to me, of pages from the Mayo Clinic guidance on obsessive compulsive disorder. But the psych eval does not provide a diagnosis of OCD, nor did I find a basis elsewhere in the record to support the assertion in your memorandum that he was diagnosed with OCD. That's one place. The psych eval also does not establish a causal nexus between the mild Alzheimer's diagnosis and the behavior that we've been talking about in terms of the excessive use of hot water. Where is the support for the argument, quite apart from the fact that it wasn't raised until post-trial? Where is the support for the argument that you advanced in the post-trial motions?
When we wrote the post-trial motion, we suspected that there was something wrong, but we did not know what it was. And so,
right, the psych eval was dated after the post-trial motions. I understand that. But even when you had the psych eval, it didn't substantiate the arguments that you made in this post-trial motions or the arguments that you're making here.
So again, the obsessive compulsive disorder did not turn out to we
Right.
don't have a diagnosis of that. What we did end up with, however, was this diagnosis of a mild neurocognitive disorder consistent with Alzheimer's. And Mr. Pena failed the MOCA test very severely, getting a 12, I believe, out of a 26 on that. Exhibited memory, comprehension, attentional issues. And those issues are 100% consistent with this diagnosis of Alzheimer's. And
I'm looking at page 7 of Record Appendix 4, in which the psychologist that provided the information that you submitted in your in support of your post-trial motion, it doesn't say that there was a causal nexus.
And I have to say, I don't believe that we asked her to opine specifically on that issue. However, Alzheimer's is exactly the type of disease where you would expect someone to leave their water running. So,
Would it also be the type of disease where you could expect somebody to leave their stove on?
I would think so, absolutely. You could leave your stove on. You forget to turn things off. In addition, we might be looking for a nexus.
You are saying this, but the professional who is qualified to tell us or to tell the trial judge what would be the consequence in relation to these behaviors hasn't said that.
Well, I believe that her report does support the existence of a nexus either between the conduct and the Alzheimer's. Or
Okay, show me where.
Because Alzheimer's is, again, the type of illness where you expect these kinds of
Where does the psychologist say that?
That is just sort of, I guess, the court can take judicial notice of that.
I think when we're talking about a cognitive disorder and specific behaviors that give rise to the serious impact on other tenants, and you've got a psychologist who is providing guidance to the court in support of your argument, it would be, we're reviewing the trial judge's actions on your post-trial motions for abuse of discretion. And it seems to me that the rather conspicuous absence of the kind of expert guidance to draw the causal nexus that your argument relies on is something that is hard for me to view as abuse of discretion for the trial judge to have relied on.
What we were asking for in our motion was for rehearing, for an opportunity actually to present additional evidence to the court on these
Right,
issues.
but you need to make a showing that that is warranted, and the trial judge, in my estimation, can hardly be faulted for saying what you've given me does not meet that standard.
The trial judge didn't say anything in his order about why he was denying the motion. It's a 7-word order that just says, after rehearing on the 22nd, reconsideration is denied. So it's not clear from that whether he's refusing to rehear the reasonable accommodation argument or whether he's denied it on the merits. And at a minimum, the case has to be remanded for him to make findings. That's required by Ajardi and other cases.
What do we do with the fact that prior to trial, Mr. Pena's counsel, and this is at transcript page 26, told the judge, my understanding was this was going to be primarily an issue of reasonable accommodation related potentially to Mr. Pena's mental capacity. When we received more information, the direction changed. And now this seems to be largely a question of factual circumstances, including the cause of the leaks and whether a physical device would avoid further problems. So it seems to me that Mr. Pena's counsel explicitly told the judge before trial that Mr. Pena was not raising mental capacity as a reasonable accommodation.
That's correct. The case presented involves a number of exceptional circumstances that were present at the time. This was COVID. Mr. Pena is a Spanish speaker, and so there was limited contact between counsel and Mr. Pena, and most of that occurred over the phone and through an interpreter. In addition, Alzheimer's is the type of illness that the person themselves is unaware of and can't alert you to, and is not something that, in its early stages, is readily apparent to anyone without sort of a substantial course of.
So assuming that you could show that Mr. Pena has Alzheimer's, and the Alzheimer's caused his conduct of leaving the water running, what reasonable accommodation would the landlord be expected to give? Would they have to give round-the-clock home health aides?
The reasonable accommodation that we requested has actually been in place for the past 30 months and has completely cured the conduct. And he has been receiving the care of a home worker for this entire period. And since then, I have not heard any complaints of problematic water use. So this is a case where the accommodation is in place and has cured it and is working. And at this point, there is no justifiable reason why a federally subsidized housing provider could evict someone for conduct that hasn't recurred.
And we can take judicial notice that it hasn't recurred, even though it's
if
not
we want
in
to
the
limit
record?
ourselves to the 7-month period, there was no recurrence of the conduct at the time that this motion was argued in April of 2022. At least there were no complaints made to me by counsel that it had happened.
Was that information put before the motion judge?
It was presented
Is that in the record?
Yes, it's in the transcripts.
In our record?
What do we
It's in
do
the
with
transcripts, yes, sir.
What do we do with the fact that there's this agreement dated 2018 between Mr. Pena and the landlord that he won't run excessive water, and that's about 3 years before the notice to quit? That can't we infer from that this was an ongoing problem for years and not just on the 4 occasions when the maintenance supervisor witnessed it?
I think we have to look at the fact that Mr. Pena has now established memory problems, and when provided with 5 words during the evaluation, he could not remember them 5 minutes later. So I think we have to consider that when we ask whether he was on notice that this conduct was problematic. There's no evidence, there's no testimony by the landlord at trial that he intended to harm anyone when he did this. He just, we all use water to some extent, and there was a point at which his water use became problematic, but there's nothing to suggest that he was aware at which point that was, or again, knew that he was harming anyone. In addition, since the conduct's been cured, since it would be devastating for him to lose this, what is housing of last resort, the landlord no longer has any reason to evict him when they're receiving federal funds in order to stabilize people that just like him. I do want to talk a bit more about the federally subsidized housing context and the fact that in that context, there is this requirement that tenants not be evicted for other than very good reasons. And in order to effectuate that purpose, the statutes, the regulations, the lease all require this additional finding of good cause that the housing court here did not consider at all. And if you look at Spence versus Gormley, you see that the court talked about this requirement imposing requirements of rationality and basic fairness. And here, when we look at whether this eviction is rational and basically fair, when we consider, again, the good faith of Mr. Pena, the fact that although people may have been deprived of hot water, it wasn't for an extended period of time, and we compare that with the consequences to him of losing his home, the record reflects that he has nowhere else to go. You see that it's not a rational eviction, and it violates the standards of basic fairness, and I think that we can't turn away from that. So at a minimum here, I think the court could. We're asking that the court vacate the judgment because there is not good cause to evict for this type of conduct that is just blameless. And even if the court does not agree with that, Mr. Pena has raised his request for a reasonable accommodation. And even if the court were to conclude that it's too late for him to raise that claim, it's still going to be the case that when the landlord physically removes him from his home, that's a discriminatory housing practice. So a decision that it's too late for him to do it is just a decision that we're going to look the other way while the landlord evicts him for discriminatory reasons. Thank you very much.
Thank you. For the plaintiff?
Good morning, Your Honors. Lisa Gouveia, attorney for the landlord, the Shoreline Corporation. I'm going to just touch briefly. I rely solely on my brief, but I would like to touch briefly on the points that Your Honors did make in regards to the questions you asked my sister to sort of clarify a few issues from the landlord's perspective. In regards to the water issue not reoccurring, it actually did reoccur during the course of the trial.
I don't have a record on any of that, I don't think.
Part of the issue, Your Honor, is that it was raised during one of the motion hearings, and the judge found that because it wasn't part of the original notice to quit, it could not come in at trial. We respected the court's decision, but I'm just clarifying that my sister was well aware it did occur again during the course of the trial.
Oh, but I'm confused now because I believe she referenced a 7-month period between the trial and the motion for rehearing. And she said that the record establishes that there were no recurring problems in that period. Is that accurate or not?
I would say it's not accurate as to the record reflecting that. I would say it's accurate as to I'm not aware of anything that I've conveyed to my sister in regards to there being reoccurring leaks during that specific 7-month period. But it did occur at least one other time while this case was being litigated. And my understanding is that Mr. Pena had a home health care worker during that time as well. And this is to say that the home health care worker, perhaps she's working a few more hours with Mr. Pena, but she was present over the last few years in Mr. Pena's unit, allegedly assisting him. So I'm just trying to clarify that that's not exactly accurate based on my understanding.
I want to clarify, if I may, just address a couple of points that you made in your brief regarding the scope of the issues that are before us in this appeal. You suggest that the arguments advanced in support of the post-judgment motions for relief are not before us because they weren't part of the original judgment. Why would that be the case?
So, Your Honor, part of my issue is that at no point in time was there an answer filed, a responsive pleading by the defendant. At no point in time during the trial was it raised that the defendant...
The absence of an answer does not preclude a motion post-judgment for relief from the judgment, either under Rule 59 or Rule 60.
But they're attempting to bring issues that were not presented at trial, either through a responsive pleading or testimony. That's the issue that I have, Your Honor, is that there literally was no testimony presented in regards to a reasonable accommodation.
That's a topic, I suppose, for an argument of waiver on the merits of the motion, but it doesn't mean that the motion itself is not a subject of the appeal. In your opposition to the post-judgment motions in the housing court, you made an argument that the Rule 59 motion was untimely because it was filed on January 18th, if I remember the dates correctly, and the judgment entered on January 6th, so it was beyond the 10 days.
We did resolve that issue at the motion hearing, Your Honor. It was determined there was a holiday in there and that the timing was correct.
Right. Okay. So you're not advancing the argument on the basis of timeliness. It's simply on the fact that it raised issues that were not raised as defenses in the trial.
They were not raised at all. They were not raised through testimony from my sister. They were not raised from anything that was brought up at trial, Your Honor. And it is not a lack of knowledge that those situations may have existed, because my brother at trial indicated that this was no longer an issue of capacity.
Right. So your challenge, I mean, that doesn't go to the question whether the issues are in front of us, but you're saying that the judge could correctly have denied relief on the ground that it wasn't newly discovered evidence.
Correct, Your Honor.
But that
evidence that was available.
I understand, but that's
available.
a substantive argument, not an argument that it's not properly before us. The denial of a Rule 60 motion or a Rule 59 motion ordinarily is eligible for review as part of the appeal from the judgment. Okay.
Thank you, Your Honor.
What do you say in response to Mr. Pena's counsel's argument that the judge should have looked more to the equities of eviction?
I think throughout this entire process, and you can see it was a lengthy litigation process from beginning to end, I think the judge gave deference to the defendant in multiple occasions, allowed motions that were filed on the eve of trial, motions that were filed on the day of trial, gave them an opportunity to propound discovery on the day the trial was going to be heard, gave him an opportunity to propound repeated requests for reasonable accommodation on the day of trial. The trial was continued numerous times. I think even on the day of trial, when they presented motions that were not properly served on the plaintiff, the judge still gave them an opportunity to put forth arguments, Your Honor. I think in this case, the judge evaluated, in my opinion, in deference to the defendant, every opportunity to provide him in his counsel, the ability to present a defense to this case. I think he was well aware of the prior litigation, because that was brought up multiple times, and I think he gave them the opportunity to do that. And I think what happened is they shifted gears and decided that they were going to focus on just one issue, which was that he was not the cause of these leaks, these water issues, this condensation, this ice buildup. And when they did that, that was the only focus at trial. And when they filed their post-judgment motions several months later, the judge's position was, at the time of trial, with the information I was provided, I made the correct decision, and he denied the motions. He also had the ability, and noted on the record, that he understood Spanish and English, so he had the ability to understand Mr. Pena more so than perhaps non-Spanish speaking individuals in the courtroom, and at no point in time did he consider him not being able to understand what was happening during the trial. And I think that's important, Your Honor, because the judge is saying, I understood what he was saying, and I, as the trier of fact, did not feel at any point in time there was an issue relating to his ability not to understand what was happening.
Just following up on that, part of the tenant's argument is not so much a legal one as sort of playing at the equities, that this problem is in the past, that it's been over 2 years since the trial. The problem has not reoccurred, they assert, and there's just no reason for your client at this point to want him out. How do you address that?
I would say that there is no guarantee the issue is not going to reoccur. I think if you were to even agree with counsel's argument that there is a capacity issue, there has been nothing set forth other than he has a home health worker in place to say that his condition may not deteriorate even more so going forward, and this could be reoccurring issues that a home health aid worker who is not present with him 24 hours a day might not be able to prevent. And my concern is this is not one occasion it happened or two occasions. There were 3 separate cases brought by the landlord for the same issues. And each point in time, the representation was that it would be resolved, that we were working on it, that thank you for granting the reasonable accommodation to keep him here, but we're attempting to resolve the issue. And at the end of the day, the focus still seems to be that the issues were not so bad that warranted eviction, which is concerning because they were. I mean, we had a buildup of 2 inches of ice that required a heat gun to remove in Mr. Pena's apartment. We had residents who were without heat in a multi-unit building. Okay, it was 15, 20 minutes, but the reality is that this is a family environment. We have children, we have people getting ready for work. To downplay the severity of that and to say it's not going to reoccur again when none of us know that is actually the case, I don't think that, in my opinion, that's reasonable, Your Honor, given the effect it could have on the other individuals in this complex.
I just want to touch on an observation that the Tenants Council made in their reply brief, that in response to their various arguments about the magnitude and significance of the eviction of this tenant from federally subsidized housing, your brief included citation to just one authority. Now, to be fair, your case was in 1916, not 1875, as cited in the reply brief. But 1916 was a long time ago, and the reply brief does accurately observe that the topic addressed in that authority was the expert opinion on a handwriting sample, which has very little to do with the issues that are before us on appeal.
To be fair, if this is going to my sister's argument that one of the witnesses was testifying as an expert.
I'm just going to your argument. It's helpful to us to have legal authority to support the arguments that you advance. And the response that you made to the tenants' rather vigorous arguments was bereft of any authority.
And there are a lot of recent cases like Bridgewaters and Glendale, and even Peterborough v. Garnier, the Rule 23 decision, that it would have been helpful to us to have the landlord's perspective on whether or not those applied or could be distinguished.
And adjective is a rather large presence in this context.
Your Honor.
I'm somewhat at a loss to understand that absence, the absence of any reference to authority.
All I can say, Your Honor, is next time I certainly will include more authority for the court. Some, and other than one case that may not be completely relevant.
That doesn't really touch on the serious issues.
I agree, Your Honor. I think lastly, Your Honor, I would just say that I understand my sister's argument that this is federally subsidized property. What I don't understand is the argument that there was lack of good cause to evict. I think the lease in question here, which was cited by the lower court, specifically outlined the provisions of the lease that the judge determined were violated. The lease is a mass housing lease. This is not a lease that the landlord created through a private third party. It specifically lists the reasons to evict, and I think the judge was very clear that he found that there were a violation of multiple provisions of the lease. So I would just say that clearly there was good cause to evict at the time the judge made the decision in that case. Thank you.
Okay, thank you. We will move then to the next case on our list for hearing, case number 2023 P83, the International Longshoremen Association Local 1413 1465 versus the Massachusetts Commission Against Discrimination. Morning, Mr. Lang. You may
Good
begin.
morning, Chief Justice. Good morning, Justices. May it please the Court.
Why don't you move over a little closer to the podium and the microphone?
Yes, sir.
Thank you.
My name is Scott Lang. I'm the attorney for 1413, 1465 International Longshoremen's Union. I have represented the union since October of 1978. This case is one where the complainant before the Mass Commission Against Discrimination filed a three-part complaint, one for discrimination based on gender, one for discrimination based on ethnicity, and the other based on retaliation. The Commission did an investigation, found probable cause, first on the gender bias, did not find on ethnicity or national origin, and then subsequently a retaliation claim was filed, and the hearing officer did not find that there was retaliation. So we're here appealing the finding that there was gender bias, and we're also here then appealing the remedies in this matter. The first issue that I'd like to take up is what we believe is a issue of preemption. And in looking at this case, and I
Mr. Lang, you mentioned in your introduction that you've represented this union since 1978.
Yes, sir.
I haven't been a lawyer that long. I have been on this court for 22 years, and I don't recall in any context the argument that you are making to have been advanced on behalf of in the context of an MCAD discrimination claim in a collective bargaining situation. I just had a case released, as a matter of fact, that involved a collective bargaining situation in a hospital, and no one suggested the possibility that the presence of a union or a collective bargaining agreement precludes an MCAD proceeding. I looked at the authorities in your brief, and they don't seem to support, or they don't say it, they don't exclude it, but they don't say anything on that topic. The reply, the red brief mentions a couple of cases, a First Circuit case, a District of Massachusetts case, that seem to suggest that's not the case. Your reply brief doesn't respond to those. I understand in theory the argument that you're making, but as you heard me say a moment ago, it's always helpful for us to have some authority to support the argument.
So this may be a first impression type of an argument, and I'll explain to the court why.
But I mean, you've been doing this for, as you said,
Very
quite a long
time.
time, and it just occurred to you?
And I haven't run into this before, and I'll explain why. In order to find that there was gender bias in the hiring in this case, which is what it is, and it's based on 5 times, we're giving the benefit of 5 times of Ms. Robar showing up at a shape. It seems to me that and by the way, people who show up for shape show up hundreds of times before they actually, they'll get on maybe once every 10, 15 times for a shape. But in order to decide whether or not there was gender bias regarding hiring at a shape-up, you would have to understand the collective bargaining agreement, the hiring rules.
Does the record before us contain a signed copy of the collective bargaining agreement that would have applied to Ms. Robar had she been admitted to the union?
I believe it does, Your Honor. I believe it does.
Because, I mean, we have a copy of the Constitution of the Union, but I'm having a hard time finding the underlying CBA itself, but for an amendment or two upon which you seek to rely.
Right.
And there's 2 copies of contracts between the union and Maritime Terminal, but neither of them are signed, and one of them spells maritime wrong.
I've been representing since 1978. That is not, I'll just tell you very quickly, I'll take 1 minute and explain. Union has been as high as 100 members. Union now is about 50. Union is 90% minority-based. It's based in the Cape Verdean community. They engage, when I say I have represented them, I don't represent them on a daily basis and often am not involved in their contract negotiations. So it is not surprising to me. I believe that you have, to answer that first question, though, on October 27th, 2008 contract with the.
We're not going to put you to the task of searching through the record appendix during your 15 minutes of time, but if you could submit a 16L letter after the conclusion of this argument to give us the record page citation where we can find a signed copy of the collective bargaining agreement in the record, that would be helpful.
I will. I also want to say one thing. In the city of New Bedford, over the past 25 years, in many cases, there are not signed contracts, but there are contracts because you can't contribute to a pension plan unless there's a contract. But it is not necessarily not a contract if it's not assigned.
But the point is you're grounding your preemption argument on the CBA, and as you heard from the questions, we're having a hard
I
time
understand.
finding the CBA in the record. And for example, you put a lot of reliance on the rules for hiring, so-called. An unsigned, undated document is, from your perspective, is that part of the CBA or
Well,
not?
let's move away from that for a minute then, because clearly the hearing officer thought she understood what the rules for hiring were. So at some point, what I would say is that what this decision from the Mass Commission is not something that they pulled out of the air. The problem is that the documents that I'll make sure were in the record. But what I'm saying is that the hiring rules depended on four things, which the Commission basically got right, which were you have to shape up. In other words, you have to be there. This is not by proxy. You have to be there each time. There's a shape when a ship first comes in. There's a shape basically after each lunch or dinner break if someone doesn't show up. So there's 3 times to shape during the course of a day. My understanding is Robar shaped the first time on October 24th, 2009, and then filed her complaint, I believe, on November 23rd or November 25th, 2009. She indicates she went to 5 shapes. So of those 5, she's claiming that she was discriminated against. The second way you get hired is by seniority. Seniority by the number of times you appear, as well as seniority if you're in the union. If you're in the union, there's rank order. So in other words, it's not as simple as walking in and saying, hey, I'd like to be hired.
But that goes to the underlying merits of the hearing officer's decision, which was then adopted by the full commission. And we can talk about the substantial evidence and the administrative deference and all the rest of that. I want to get past the preemption question.
Okay, so then let me put that off to the side. By the way, my feeling is if there were remedies included indicating in the complaint that they understood that Lee was going to the NLRB, which is where the remedy was. If you have an unfair labor practice, if you believe you've been discriminated against in hiring in a union, you go to the NLRB. They went to the Mass Commission. The Mass Commission, the hearing officer not understanding any of the qualifications of being hired, which after everything I just indicated is qualifications. They hung their hat at saying she had a certificate to run a forklift, but she only wanted to run it on the docks, and also that she had a Twix card, which the United States government had a great idea and program with Twix, but it evaporated very quickly, and by a certain point, there was no such thing as requiring Twix on any docks in America. It was a 1-for-5 ratio at a certain point. So they hung it on basically issues that don't determine qualifications. The only indication that she was qualified to run a forklift was Kudo, who at that point was no longer shaping up, testifying that he saw her run a forklift on a dock for 3 or 4 minutes, or let's say 10 minutes, even 15. But that does not qualify you when you have people who...
But now we're back into the evidence, and I'm happy to talk about the merits, but the preemption question doesn't turn on those details, right?
Well, no, I don't think so, because then we're back to the evidence saying that if you don't understand, let's assume this is any industry. Forget about an industry that I think would preempt. the commission looking at this case. The reason is because they don't understand the industry.
But your argument would not depend on particular industries. If preemption applies because of
Right,
the NLRB role over collective bargaining contexts, it would apply to hospitals, it would apply to auto body shops. I mean, just anybody that's a union shop.
But it only applies if it has to do, if the nut of the complaint has to do with the rules under the CBA as to how you're hired. If the union.
Why wouldn't it apply if it concerns promotions or workplace conditions or overtime or anything else?
If the CBA covers that,
Yeah,
it would.
yeah.
But for instance, if a union member, went up to someone and made disparaging remarks which turned into a harassment case, that's not covered by the CBA. But if it's covered by the CBA, that's why I indicate either you have to understand the industry and understand the CBA in order to make decisions in regard to evidence, or it would be preempted and would go to the people who do this on a daily basis. The hearing officer in this case, on the second day towards the end, indicated in the transcript, can you please explain to me again what a shape-up is? The whole matter was, why was she not hired at the shape-up? And if you don't understand that, forget preemption now. If you don't understand that, it can't be substantial evidence. The fact was, they treated this as if she went down to the mall, applied for a job, and people said, let's not hire her because she is a woman. The qualifications to be hired in this particular case are extremely, extremely strict. And I'm not saying she was not hired in the past. She was hired as a rapper, which she was qualified for. She was hired at one point. They taught her how to do sign, and she was a lander. But running a forklift on the docks or in the hull of a ship is something that you just don't simply say they passed her over, so therefore they must have been biased against her from a gender standpoint. The test of this case, forget preemption, is whether or not it's supported by substantial evidence. The two people who testified for Robar was someone who thought he cut a deal to get work if he did plumbing.
And the hearing officer found those two people credible as opposed to the union's witnesses whom she did not believe.
And Justice, let me explain something. One of the people she found credible was convicted of a felony regarding the union, removed from office under Landrum Griffith, and she found him more credible than three individuals who had served as presidents of the union over the past X number of years. Well, no, but the point, at a certain point, if justice
You asking
is
us
served,
to not just simply disregard, but to set aside and reach a contrary conclusion to the hearing officer's assessment of credibility?
That's why I'm here, Your Honor, on top of the 3 or 4 arguments that we made. This, I have not, I'll just say, I have not seen a case that is, when I argued this in Superior Court, I indicated this would be like doing a study of the Red Sox past season and saying that they didn't score enough touchdowns. If you don't understand the rules, how in God's name can you then find that they discriminated against someone?
What do we do?
For the record, they didn't score enough touchdowns.
I agree with that. I agree.
The football team isn't scoring many touchdowns either.
Or home runs.
Say.
Yes, I agree, Your Honor.
What do we do with the evidence of the position statement of the union? We've hired females in the past and have the hours to prove it. These other women did not complain to anyone when they did not get hired for other positions. They more or less knew their place when work was issued and accepted it.
So that is so taken out of context. This is a rank order system. There is a list of numbers of people. It goes by the list and when you are hired. What Lacombe was saying was they understood their place regarding the rank order list. It goes completely by seniority and qualification. So if I'm a rapper and I go to apply to be a winch person, I'm not going to get that job. I'm not going to get that job if I apply for a forklift operator unless I can prove I can forklift. And the other thing that they don't understand is there's complete reciprocity with the Providence local. And that's shown by the fact that Robar herself went over to the Providence local, worked without missing a beat, and drove a car. There's a big difference between driving a car and driving a forklift, which basically picks up to 9 tons of material. So what I'm saying to you is that analogy is a bad analogy, but I'm going to use it again. The Bruins didn't score enough 3-pointers last year. I mean, if you don't understand the rules, you cannot decide that someone was discriminated against. In fact, when I read this report, now I want to switch to one other thing, but when I read the report, it's not supported by substantial evidence because she didn't understand what the industry was. And that's why there is preemption. The last thing.
Let me just ask you a very specific
Yes, sir.
question, which is, as the MCAD says in their brief, the union chose on more than one occasion people that did not have a certification over her. Is that accurate?
It's not only accurate, but it says in the contract that having a certificate does not determine that you get a job.
Does not guarantee you a job.
Right.
But it appears to read as if it's a baseline requirement of the position.
But it's not, because if you read the transcript, the training course was about an hour and a half video, and then filling out a test.
I'm talking about the black and white of the document on which you rely, the
Right.
March 2009 amendment.
And that amendment, Justice, please, says that having a certificate does not guarantee that you will be hired.
Well, understood.
And also does not.
But it doesn't say, and we can hire you even if you don't have a certificate.
Right, but what it does say is that having a certificate does not mean you're qualified. And it does say that as well, is not an indication of qualification. One last thing, please.
Very briefly,
Yes.
we're already well over time.
I appreciate that, Chief Justice. When the remedies, I think, far exceed the parameters that the Commission
Your
has.
argument on that in the brief. Thank you.
Thank you.
For the Commission?
Good morning, Your Honors. Thank you. May it please the Court, my name is Peter Mimmel on behalf of the Commonwealth of Massachusetts Commission Against Discrimination. This is a sex discrimination case under General Laws, Chapter 151B, where the Commission investigated, prosecuted, and determined after a full hearing, and the full Commission affirmed that decision, that the ILA and Joseph Forts, who was the president of the ILA, discriminated against April Robar when they would not pick her for work on the docks of New Bedford, and excluded her from membership from their union because of her sex. The substantial evidence is that they did so because she is a woman. The decision is not preempted by federal law, as the union has belatedly argued, and accordingly we ask you to deny the appeal. May it please the Court, I'd like to first address the issue of the substantial evidence argument first and get into the federal preemption argument. The Commission's decision was supported by substantial evidence. In this matter, the union has explained, and they're trying to rely on facts which the hearing officer heard and denied. Instead, the hearing officer determined that there was sex discrimination, a violation of General Laws Chapter 1.
You've heard the union's argument here this morning that the hearing officer's decision reflects a fundamental misunderstanding of the industry, and that the hearing officer, as a consequence, was unqualified to accurately assess the evidence, so that while there may have been evidence, it was misunderstood in the context that the hearing officer was required to evaluate it. How do you respond to that?
The hearing officer made a decision based on the record evidence and had a more than adequate understanding of the industry that was set before her. She had a clear understanding of what a shape-up is and what has to be done. She had a very clear understanding of the direct evidence of a discriminatory animus that was on display by the union and Mr. Forts at the shape-up process.
Let's talk about that for a moment, because there were several comments that the hearing officer seized on. The closest I see to a comment by someone who was in a position to make hiring decisions was a supervisor, a hiring supervisor, who shushed a union member who made a blatantly discriminatory comment, saying, "You can't say that."
So the comment was made by Mr. Forts, who's individually liable. He was the president of the union and the vice president at the time that the comment was made. The comment was made in the context of Ms. Robar raising her hand to be picked for a job, being passed over again for that job, working on a fruit boat as a forklift operator. And then when she complained about it, the response from Mr. Soares was, "We don't pick women to work on fruit boats." And the president, or the former president, the vice president of the union's response was to shush him. And the hearing officer, as is her prerogative, interpreted that as, "Don't say the bad thing out loud. Keep that under taps." And that's
So this was during a shape-up?
This was in the context of Ms. Robar being denied, yes, being denied
So he shushed him, but then he also didn't pick her.
That's correct. That's correct. And that's one of the comments, Your Honor. I would also point out that, Your Honor, that as far as...
I didn't think that comment, that shushing was by the former president. I thought it was the other way around. It was the shushing was by the current incumbent, and the other comment was by the former president, who was out of office at the time he made it.
It was Mr. Soros that made the comment. Mr. Forts, who was the president, and then shortly thereafter, the vice president of the union shushed her, what the record reflects. That is one of several pieces of direct evidence that the hearing officer relied upon. The other one is the other comment that was referenced earlier in the argument you heard earlier, where the then president of the union, Mr. Lacombe, had mentioned said that these are the women who these other women did not complain to anyone when they did not get hired for other positions. They more or less knew their place when work was issued and accepted the outcome. And the union had tried to argue before the hearing officer that was taken out of context, but the hearing officer evaluated the record evidence and determined that's not the case. This is evidence of discriminatory conduct by the union. And she balanced that against several other pieces of direct evidence. The fact that not a single woman has ever, in the history of this union, been a member of the union. The fact that not a single woman has ever worked on a fruit boat in the ports of New Bedford. The fact that not a single woman has ever been assigned to work at a shape-up to operate a forklift. When you combine all of these together and compare it against, that is strong direct evidence of a discriminatory intent by the union to deny women the opportunity, and Ms. Robar the opportunity, to work as a forklift operator. There's also strong probative circumstantial evidence that the hearing officer found in this case. She determined that Ms. Robar was qualified to operate a forklift, and that's not just based on strictly the terms of the collective bargaining agreement, which certainly do say that forklift operator, that having that certificate by maritime is a qualifying, is something that is a requirement. It's not the preeminent one, but is a requirement. The record evidence that was relied on by the hearing officer was that Ms. Robar also presented that she had on-the-job training. She had prior forklift experience working in her prior jobs. 4 years worth of experience working as a forklift operator, on-the-job training at Ocean Spray, and also she received a forklift certification from Ocean Spray. She also became credentialed.
Can I just stop you for a second? The union's argument is not irrational that working a forklift in a hold that's swaying with the water in a confined space is different in some respects than operating it otherwise, such that the person picking the people at the dock, the argument has to have some discretion in choosing people who have done this before. How do you address that?
I suppose in two ways, Your Honor. First, at some point, someone has to be given a shot to do the work, number one. But number two, it's clear from the record the hearing officer had made the decision on it was that Ms. Robar had actually done the work informally. She had been trained to do the work as a forklift on the docks of New Bedford. That's one of the findings of fact on the record. And in fact, that in that informal training, it was the people who had trained her said that she did an outstanding job. That was their assessment. She possessed the certification. She fulfilled that requirement that was imposed upon them to have the certification. She did some of the work informally.
To what extent are you arguing that the union discriminating against her by violating its own CBA and or whatever rules come with that? To what extent are you arguing that the CBA and or the attendant rules themselves are discriminatory? And to what extent are you arguing it's beside the point, there was discrimination here regardless of whether or not the CBA was discriminatory or they violated the CBA?
Thank you. I would say, Your Honor, that the focus of this complaint and the focus of this decision is on Mr. Fort's decision-making, and the union's decision-making and the bias that tainted it. And that in fact, that they either departed from, that the Commission's use of the CBA is to demonstrate how they either departed from the rules of the collective bargaining agreement. It shows that she also, or that she met the requirements that were even fit within it. It's evidence that helps support the conclusions that Mr. Fort's and that the union would not allow her to operate a forklift on the docks of New Bedford. It's their conduct. That's where the focus of the complaint is. What motivated the decision makers at SHAPE? Was it because that she didn't truly have the qualifications, or is it because she's a woman and will never work in a fruit boat because we don't hire women on fruit boats?
Let me see if I understand your response to Judge Milkey's question, because I think the way that he described the three possibilities is helpful in framing the argument here. If I understand your response correctly, what you're saying is that the collective bargaining agreement provided a series of criteria that guided hiring decisions, but it did not dictate the application of that guidance in any particular instance, so that the discriminatory conduct that is at the center of this case didn't violate the CBA. The CBA doesn't necessarily dictate discriminatory choices, but that the choices that constituted discrimination were the application of discretionary decision-making that was within the scope of the permitted choices under the CBA, but nonetheless violated the law because they were discrimination on the basis of gender. Is that your response?
Your Honor, I think that the focus, as I said before, is what was motivating their decision-making. When the decision-makers are at shape and they see a score of people who are raising their hands to say who can do this work, and when they're consistently picking men instead of women for that work, forklift work, and that, it's that conduct that they're looking at, and they're comparing that conduct against, for instance, what is said in the CBA, against the fact that they've never selected a woman to do this work. They're looking at the full circumstances of it. The CBA is a part of the equation, but to be clear, this is not a decision by the Commission. It's not rooted in the CBA. It's not derived from the CBA. We're not interpreting the CBA. We're not trying to. We're doing nothing. Not nothing. What we're really focused here on is why is it that Ms. Robar, who gets the certification, shows up for SHAPE, puts her hand up when called for by Mr. Forts. Remember, and the record reflects that Mr. Forts asked for people, raise your hand if you have the certification for the maritime certification. Ms. Robar raises her hand, passed over, not given the work. That certainly does indicate that having that certification is a qualification. That's reflected in the record. I guess the point is, Your Honor, is what is the discriminatory bias that's present here? And it's clear from the record, from the history of the union, the history of women being denied opportunities to work as a forklift on the docks of New Bedford, that it's because they were a woman, which is prohibited by the state statute that's at issue here.
We'll spend some time talking about I'm sorry, do you want to?
I just want one last question before we turn to preemption. To what extent are you relying on the switch from 300 hours of cumulative service to 400 hours in a given year as evidence of discrimination, given that it was done in the same time period as the Cynthia Lee matter before the NLRB?
I would say that Your Honor, that the Commission's decision reflects that the hearing officer was convinced that that switch was done in such a way that it was to make it harder for women to join the union. And I think because of the timing of it, it was done during a time period and contemporaneous with complaints that were raised by Ms. Lee and also by Ms. Ms. Lee in particular, about their treatment. And so the response is, well, we're going to make it harder for women to. That's how the hearing officer took that evidence. So you want to address preemption. So, Your Honor, as we raised in the brief, fundamentally there are two arguments we raised there. One is that, at least with respect to Section 301 of the LMRA and also the ERISA, that those are waivable affirmative defenses. They never raised those.
What's your case for that? Because there seems to be some case to the contrary.
So with respect to Section 301, I would refer the court to Sweeney versus West Vaco. The site is 926 Federal 2nd 29. It's a 1991 decision out of the First Circuit. That makes it clear that the employer in that case forfeited the right to raise the argument. And with respect to ERISA, I would refer the court to Wolf versus Reliance Standard Life Insurance Company. Site is 71 Federal 3rd 444. It's another First Circuit decision. That one made it clear that the ERISA preemption does not affect the choice of forum. I guess the fundamental argument here, Your Honor, is that ERISA and LMRA are Again, it's not a choice of form question, it's a choice of law question. It's an affirmative defense. It should have been raised. It wasn't raised.
Why is that not jurisdictional?
Pardon me?
Why is it not jurisdictional? If it stands by virtue of preemption outside the authority of the commission, it would seem to me to go directly to jurisdiction, which of course is not waivable.
Well, I would rely simply on what the cases had said there. Frankly, Your Honor, what I would rather, the waiver argument is one thing. I think that even if the court is not convinced that waiver is in effect here, substantively, these cases are not preempted by whether it's under the NLRA or ERISA or the.
Let me ask a very targeted question because we're running out of time on ERISA in particular.
Mm-hmm.
We didn't have an opportunity to speak with Mr. Lang about the scope of the remedy, but the remedy, among other things, requires the installation of the employee to the union retroactively to an earlier date that would, among other things, grant her seniority for purposes of status within the union, but for purposes of ERISA also would give her credit under the union's pension provisions for a period that she wasn't formally eligible. Doesn't that implicate ERISA?
I would say, Your Honor, that when we look at the order, the hearing officer was clear that the order was that Ms. Robar would be placed in the position of and get whatever benefits are available to her, leaving it to the benefits provider to determine what those benefits are. I think that what the hearing officer has done here with the commission's decision changes. It doesn't change the terms of a benefit plan. What it changes is it tells her, take Ms. Robar as though she met the requisite number of hours. We're going to work within our prerogative or our sort of authority to give a broad remedial authority to put her in the position she would have been in had she not been denied opportunities to work. That she would have, based on the record evidence, she would have attained the 300 hours. And then it says to the union, now you're going to treat her as though she met those requisite hours. Confer her union membership. And as far as the benefit plans are concerned, the commission's order does not say to the benefit administrators, change the terms of your benefit plans. What it says is, you're going to presume she met the hours requirement. Now treat her as though you would treat anyone else who met those hours requirement.
But I have no idea what that means in practice. She wasn't paying, was she paying into the benefits program throughout that time or not?
Your Honor, I would think that the answer to that would be, I don't know the precise answer to that. I think what the order is to, well, and actually it does a couple of things too. It does put her in that position. And in addition to that,
what Judge Milkey's question illustrates is that we don't have any idea, and it appears on this record that the hearing officer was similarly situated. We don't have any idea what the potential ramifications of that order might be as it relates to the pension.
Well, Your Honor, I think that what it does is that it tells the administrator of the benefit plans that you're going to treat her as though you treat any other member who presents to you that they've met the hours requirement.
Right, but what that translates into in terms of real-world effects or ramifications is entirely unknown.
Well, I suppose it would leave it to the benefits administrator and Ms. Robar to work that out, but what the point is that it would have to be that she ought to be placed in that position.
But that bears on, to some degree, potentially bears on the question of ERISA preemption.
I suppose it would, Your Honor, but it certainly doesn't violate the essential terms of it, I would think.
Okay. I think we need to bring this to an end.
Your Honor.
I will say here this morning that we have had some internal discussions within the panel about the possibility of soliciting amicus briefing on the question of preemption because it is a novel question. It doesn't seem to have come up in a large number of cases, so we haven't made a decision on that yet, but I just want to alert the two of you to the possibility that you may see an order to that effect in the coming days or weeks.
Thank you, Your Honor.
Thank you. The next case on our list is case number 2023 P0007, Mary Catherine Connors versus Kevin G. Connors. Just as a reminder, we will be taking a brief recess following the conclusion of the argument in this case.
morning, Your Honor. My name is Gary Greenberg, and with me is Norman Bigelow, and our client, Ms. Connors, is in the courtroom. Thank you. Your Honor, just from an oversight, the probate court made a decision that was, number one, contrary to the law. Number two, contrary to undisputed facts. Three, it was a decision that effectively sanctioned Mr. Connors' lies of both the court and Mary Kay in his deception. It sanctioned Mr. Connors' refusal, failure to provide the most basic information concerning significant financial transactions. Again, and these are not minor transactions. Two transactions are worth just noting. One is the interface. There was testimony at trial. Not only didn't we have the information, but it involved a sale of between $272 and $275 million, in which had post-earnout payments, post-divorce. Number two, another sizable transaction, numerics. Testimony at trial, again, it has earnout payments, post-divorce of $245 million. We faced a trial, which it was because Mr. Connors admitted himself that he promised under oath he was going to provide financial information, he was going to provide company reports. Never happened. Never happened. We asked the court, among the other relief that we asked, was the need for a forensic accountant, someone to force the issue, to find out what happened to all of this money. Mr. Connors, again, the testimony is clear. Mary Kay raised 4 children. She used her family money to provide education for all of them. Mr. Connors spent his time and was Harvard-educated MBA. No dispute. He built a joint venture for 40 years. He was the co-founder, managing partner of a joint venture fund. He was a very, very, very successful private equity investor. He was the CEO of over 6 companies. He was in total control. He controlled how he got paid. He controlled the company that he set up, which these people, their money, their assets, were essentially their investment in Spray and their marital home. Okay, and any assets that Mary Kay may have inherited. Their money went into Spray. Mary Kay had an interest in Spray. Mr. Connors was an investor of at least 12 patents. That's what he admitted. He was largely paid. He controlled the company. He controlled how he was paid. He was paid in part by getting equity in these companies. So when the company got sold, he would get a significant payday. Again, Mary Kay testified, and Mr. Connors didn't dispute it. He had all the information. He controlled all the information. He controlled Spray. He possessed information.
The arguments that you are making here seem largely to fall outside the specific claims of error that you advance in your brief.
No, Your Honor. Actually, what I'm focusing on is that among the relief we sought was not merely the economics, which I think is fairly straightforward. I mean, I can go through those.
But you've raised 3 specific errors, as I understand it. The first is that that it was error as a matter of law in interpreting the parties' postnuptial agreement regarding alimony not to count the capital gains realized on the resale of the marital home following the award of that. And you're also arguing that it was error not to find a contempt for the failure to pay alimony that wasn't known. All of this other sort of financial shenanigans that you are alluding to here don't seem to me to stand at the core of any of the arguments that you're making in your brief on appeal.
Your Honor, it certainly wasn't in the core of the court's view, and that's the point. We asked the court, and we did, for a forensic auditor, specifically the relief we sought. So that's the point I'm trying to make.
Well, I understand that the point that you're trying to make. I'm just commenting on the absence of that point in the issues that you framed in your brief for consideration on appeal.
Well, respectfully, Your Honor, I think the brief makes it clear that the request for a forensic is part of a remand request for an audit. Let me just address the specifics that you've said. Number one, with respect to the marital home, which is the word they use. This was an investment. He testified under oath this was an investment. It's undisputed that he lied to the court. When the court was deciding who was going to receive the property, he said to the court...
I'm having difficulty understanding. I mean, I understand that you are offended, as one should be, by someone who makes a misrepresentation in a formal legal proceeding. But it seems to me that the legal error that you are ascribing to the judge has nothing to do with misconduct, but has to do with the misinterpretation of the parties' agreement. Why don't we focus on the application of the law to the gain rather than an ad hominem attack against the individual?
Well, correct, Your Honor, except that we did make the argument that the lie constituted independent contempt.
I understand.
Okay, but we'll just focus on the fact this is a clear and unambiguous agreement. For them to get up and say that the word gross income is ambiguous, which says including without limitation and lists a whole bunch of things, capital gains, it is undisputed that we're talking about profit that he made. Profit he made on what he testified was an investment. Respectfully, the probate court judge, when she made a comment, are you talking about him only getting 1/4? When we tried to correct her, we said, we are talking about the approximately $850,000 profit he made from an investment.
Why does it matter whether it was an investment or not an investment?
It doesn't, Your Honor. Respectfully, Your Honor, it doesn't.
So let's just focus on what the agreement provides and why you contend that the exclusion of these gains was incorrect.
Your Honor, there's no other way to, the court did not find this unambiguous. I'm sorry, the court did not find it ambiguous. There's no finding that this was vague or indirect.
The court's rationale was that because it was the resale of a division of the marital estate as part of the divorce, that gains on that share of the marital estate are not counted for purposes of income.
Respectfully, Your Honor, that isn't what the agreement says. Secondly, Your Honor, and the agreement has its own independent legal significance, a fact that the judge seemed to forget.
What do we do with the fact that the agreement was signed while the Alimony Reform Act was a twinkle in the legislature's eye, and under the Alimony Reform Act, this never would have been permissible?
Respectfully, Your Honor, this was a hotly negotiated agreement that went up before this court, went down, was a remand judgment. The judgment, no one ever suggested that there's any ambiguity. I don't believe, respectfully, that anyone can say that the profit from this house was not gross income, that the profit from this house was not capital gain. Effectively,
what is the import of the Alimony Reform Act on interpreting the contract? I take it your argument is in part that parties are free even now to agree to something different than what the Alimony Reform Act says. But, even were we to accept that, isn't the Alimony Reform Act still relevant in terms of at least putting a thumb on the scale in terms of how you interpret an agreement?
Your Honor, anything is appropriate to consider. But remember, this agreement has a specific provision. Not only does it define what you pay alimony on, it doesn't matter who makes the money. If Mary Kay had made the profit, she would have had to pay. That's what it says. But it says in here, page 15 of the agreement, it makes it very clear that neither party can cause to be inserted or request that there be any decree, order, or judgment that may, in the future, be inconsistent with any of the provisions in this agreement. The law is fairly clear that when respect to people that are represented, that they are free if they're represented, they make it, and this is a Harvard MBA person that was well represented.
Well, so would Mary Kay have to pay him half the capital gains on the $1 million that she got when he bought out the house from her?
He said it was reinvested. She didn't make a profit. This was specifically testified to. And just so I'm also responding, they say, well, she...
Didn't the investments generate income?
Yes, Your Honor, all of her income, she testified at trial, all of her income was from the excluded assets. Her only, this is important to
What
understand.
happened to the money, what happened to her share of the buyout, the proceeds of his buyout?
It was invested in her home. She had to buy another house. She bought another home. This is all stuff that was covered, and we were prepared.
I thought there was evidence that she invested that into an investment account.
Your Honor, Your Honor, just understand, she testified to that she had to buy another home, and it was $1 million something that she had to pay, okay? And the point I'm trying, I mean, they can claim whatever they want to claim, but no one ever asserted.
I'm working off of the judge's rationale, not the red brief.
Your Honor, respectfully, her assertion just ignores the language, ignores the fact that there is no construction of this agreement that would allow a definition that doesn't include
But
this
isn't there a
being gross
public
income.
policy behind both the Alimony Reform Act and the previous alimony statute that when people are divorced, they're divorced, and they're no longer in each other's business, in each other's financial information at every step of the way? And so I'm having a hard time understanding how this contract provision doesn't conflict
Your Honor,
with the Alimony Reform Act.
respectfully, the parties, the law is pretty clear in the state that the parties are free to contract. This was an independent legal contract.
Right, and so...
if the issue is, did what happened violate the independent legal contract, which this court in subsequent remands has said is valid and enforceable. So, for Your Honor, the consideration you're making, and they're all legitimate considerations, the simple problem is that the law is, if this is a contract, and this court has already decided it's a contract, and if there's no ambiguity, and the parties freely entered into it, which the parties said, that's the end of the discussion.
Going back to my earlier question, but rephrased somewhat, why doesn't the existence of the Alimony Reform Act in effect create an ambiguity in the contract in terms of whether or not that provision applied to the marital assets that were divided?
Your Honor, again, first of all, the court did not find an ambiguity. Secondly,
Did they
didn't find this. The probate court didn't find an ambiguity. What the probate
Did
court
the probate court judge say it's unambiguous?
No, she didn't find any ambiguity whatsoever. She did not find. What she said is, if I knew you were going to interpret it this way, I would not have found it fair and reasonable. That's essentially my take. Or Mary Kay, you have enough money, so you don't need this money. Ignoring the fact that this is a multimillionaire who had, in his financial statement, had set forth undetermined, as he's the only one that knows the value, but all of his listed assets, it's all undetermined.
When you say the court didn't find an ambiguity, what do you say about the judge's memorandum at page SA7? Multiple aspects of the post-nuptial agreement were unclear or not binding on the parties.
Yes, that was.
And then she goes on to talk about how the post-nuptial agreement doesn't define gross income, and she looks to the Alimony Reform Act for the definition of gross income.
Respectfully, gross income is not an ambiguous term. Gross income is income gross. And no one can, the court didn't say that this profit wasn't gross income. I mean, again, this is a separate, distinct contract that this court has found.
Under this contract, I have a question about the house. If the husband had, instead of what you refer to as flipping the house, if he'd stayed living in, this is the Livingston Road house, for another 20 years, and he had died in the house, and then his estate sold the house, would his estate owe half the proceeds of the capital gain?
The answer, I just don't remember if the agreement is binding on heirs. If he had sold it during his lifetime, sure. I just don't remember whether.
Is there a period of time?
No.
When it no longer becomes a flip?
No, it is. I mean, you're positing different facts, but I'm simply saying the contract's clear. Forever. for as long as they live or until she remarries. That's what it says.
But in Anson v. Craven Anson,
I'm sorry?
in Anson v.
Yeah.
Craven Anson,
Yeah.
that post-nup valued the assets as of the time of the divorce, right?
But, I mean, again, the parties represented by counsel entered into a contract that was fairly simple. I mean, the only, look, our brief is fairly straightforward. I mean, in terms of it, I think Your Honor understand the argument. I just want to say just a couple of very brief things. On this, on the contempt, if I can, on the contempt.
We have your brief on the contempt as well,
Okay,
and we're
thank
past
you.
time.
Thank you very much, Your Honor.
Good morning, Your Honors. My name is Alexander Jones, and with my colleagues Jim Brick and Valerie Cooney, we represent Kevin Connors. And notwithstanding what I think we just heard in the briefs, I think this is, as you pointed out, this is a fairly simple kind of question as to whether or not the trial court abused its discretion in interpreting, not finding Mr. Connors in contempt, and interpreting the contract, and then with respect to the child support.
I'm having a hard time understanding the rationale that seems to undergird the judge's decision not to count the gains on the sale of the property as income. If I understand the judge's explanation correctly, the reason that gains on the resale of the marital home were not treated as income is because that was part of the marital estate that was divided and awarded to the husband in the divorce itself. What assets, other than those expressly excluded by the postnuptial agreement, what assets would either party have that were not awarded to them in the division of the marital estate that would be capable of generating capital gains?
That would be generating capital gains in themselves.
Yeah.
I think it would be, to the extent that there were the investments spun out money and the other assets that were divided at that point in time, those invested and reinvested, those would trigger
Okay, I understand that
capital
they're in theory, but you know, there were other assets that each of them held, and those were divided, right? That there were assets that were in the marital estate that were not excluded.
gains. Correct.
And some of those went to the wife and some of those went to the husband,
Correct.
including stock options, including shares of stock.
There was, correct.
Right. So presumably, any sale of that stock that was awarded to the husband as part of the division of the marital estate that resulted in capital gains, that those gains would be included as income.
Those gains would be, those gains would be included as income to the extent on a stock option, to the extent you exercise it, and there's the
Right.
difference.
But they were awarded to the husband as part of the division of the marital estate.
Correct.
right?
Correct. There was, the
So
assets
the
were
fa-
divided,
so the-
assets were divided equally.
Right. So the mere fact that, an asset that later generated a capital gain was a part of the asset that was awarded to, it was an asset that was awarded to to either party as the division of the marital estate is not categorically a basis to exclude those gains.
I think the way the judge looked at it in the 2019 remand, there's language in that opinion that I think you have before you in the appendix. It says, to the extent that neither party earned income, then there wouldn't be alimony. And it was tying it back to an earning piece of it as she wrote the decision when she upheld the postnuptial agreement in 2019. So
The confusion I'm having is that I'm having difficulty understanding why the real estate was treated differently for purposes of future capital gains counting toward the computation of income than stock or other equities, options, you name it. Because, as we've just discussed, all of that property broadly speaking, was the subject of the division of the marital estate. And yet it seems obvious, to me at least, and I think you've acknowledged, that at least some of that property, if it generated capital gains in the future, would be treated as income. Those gains would be treated as income.
I think,
But the home would not, and
I'm sorry, I think I misunderstood your question before. When you ask it in terms of income, I think, and I apologize for this, I thought it was resonating, it's taxable income, which was, I thought, what the question was, as opposed to that part of it. So I think, to the extent we had a dialogue there, I may have misunderstood your question, because I think going back to the question you asked my brother on his oral argument, it's the same issue that comes from the $1 million+ in investments that went into an account, which are sitting, as best I can tell, and it's in the on the financial statements. It's in I believe it's Appendix 4. It's sitting in a bank account. The judge made a credibility finding about Mary Kay that there would have been income from that account, and that wasn't included.
but
So I
why
think it's
shouldn't
really-
that also have been included?
Why shouldn't that
Yeah.
included?
I mean, the point is that if the agreement provides that capital gains are included, then the source of the asset generating those capital gains as being the product of the division of the marital estate shouldn't be an exclusionary, a categorical exclusionary rationale.
Well, I think when we look, so if we look back at the Jones case, which had that was decided last year by this court, where it was any manner of bonus was an ambiguous term. And I know the judge didn't find it explicitly ambiguous in this agreement, but I think that was pointed out in the supplemental appendix that the gross income definition was examples, but it wasn't clearly defined. When we looked at what happened in the Jones case and what the instruction that was kind of given by this court to the trial court was, you look on one hand at what the agreement says, and if there's ambiguity or not clarity in that agreement, you look to the intent of the parties, and the best way to tell the intent of the parties was to look at their actions. And if we look at the actions by both parties, neither party paid alimony on any of those issues that you're talking about, be it stock options or assets that were divided as part of the divorce. There hasn't been Mary Kay paying income, alimony to Kevin to do that part of it. So when we look at those pieces, there's been consistency of what their actions are. And I think when we go back to interpret the agreement, we have to look at what they did, because we weren't the ones there, and as part of it. And I think to say that there's not, again, it would have been helpful if the judge explicitly wrote, as opposed to the section, the supplemental appendix with that memorandum there, that it was an ambiguous piece of things. But I think when we look specifically at the capital gains definition that's used, I don't think any one of us can look at this and know what capital gains means. Because we have the IRS statement, which would have dealt with capital gains back to the time of the acquisition of the house in 1999 till it sold in 2021. That's one definition of capital gains. That's the IRS. The other one is the one that was pointed out before, which is the Alimony Reform Act. I think that's where we have to look for instruction on how to look at this, because there's a definition in the child support guidelines of how do we look at capital gains. And this is not, and it predates this. The looking at capital gains, or, and it comes in the Wasson case from, I think that predates the Alimony Reform Act, where is this a recurrent, kind of consistent, definite, source of income? So the child support guidelines piece, where it triggers, says, look, is this a regular, reoccurring source of income? There's the sale of one house over 20+ years. Here, I think that's the definition we have to look for. The definition that Mary Kay's advancing as to what a capital gain isn't grounded in the tax law, isn't grounded in the Alimony Reform Act, the Child Support Guidelines, which are the income definitions for the Alimony Reform Act. It just seems to be one that's made up on the facts of this case as a difference between, the flip piece of things that they described.
Yeah, but it may well, whether her proposed advocacy is the final solution is a different question than whether the judge's rationale is coherent.
I think the judge's rationale, part of it, ties, as we look to the same paragraphs where she was explaining in 2019 how she was analyzing the examples of income under the gross income definition, where she gave as examples, she went back and looked at the Alimony Reform Act and Section 53B of Chapter 208, and we will look at what the case law suggests. Again, with Jones, we're supposed to go back and in trying to construe an agreement here, you're supposed to follow the intent of the parties and Chapter 208.
But the parties presumably did not consider the effect of the Alimony Reform Act in negotiating this agreement because the act didn't exist at the time.
The act, and now I'm kicking myself for not going back and looking when the act was enacted, but I know that it became effective in March of 2012. We know it's the Alimony Reform Act of 2011. I don't know when it was passed. I know it was an ongoing part.
September.
Okay. So, but it wasn't that this was, and I know Attorney Kane, who was counsel at the time, was certainly involved as this was a long ongoing discussion because the Alimony Reform Act was triggered by the the discussion for it as part of the, the bar was after the Pierce decision predating that. And again,
I understand that the act itself didn't simply drop out of the sky all of a sudden, and that it had been the subject of a considerable discussion, both within the bar and at the legislature for a number of years before that.
And I think it's important to note, too, that it didn't change the purpose of alimony and the structure of alimony. I mean, it codified things in a more kind of coherent, defined way than it was.
But are you acknowledging that whatever the Alimony Reform Act says on this point, the parties were free to reach their own agreement, at least so long as they were clear in doing so?
I think the last part of your question is the key piece. Certainly the parties are free to contract, and they're allowed to contract as long as it's approved by the court and doesn't kind of go beyond the bounds of what it looks like in terms of enforceability. But whether a court would uphold it as being kind of under the Anson case and the rationale there in a postnuptial agreement. So they're free to contract for those things. The problem here is the clarity of the contractual agreement, and what the judge did was, as best we can tell, is clarify what the contractual terms look like that were not precisely drafted. And I think part of the problem of it, because as you look at the history of this case, it's been fairly contested. They've never been able to take that postnuptial agreement and memorialize it into any kind of clear document that would say alimony is due on this date, which I think every other case that's probably before you or the fight on a contempt would say that.
You want to spend some time talking about the contempt?
Certainly. So I think the contempt piece is there's several pieces of it, as I think, distill out. The first part is whether the judge erred in not finding Mr. Connors in contempt for not paying alimony. I think the standard is fairly clear. Clear order, clear violation of the order. The judge's rationale was...
Well, there was no specific date, but this had gone on for years, despite the existence of an acknowledged obligation to pay something, and not a great deal of debate over the basis to determine the amount. So the law in this area is, I will confess that for myself at least, I don't find a lot of formal, clear, rigid rules in the law of domestic relations, but this is one place where it seems to me it is clear that a party may not unilaterally decide not to comply with a provision of a divorce decree or order based on an argument that about its interpretation.
I think if you frame the question that way, that's correct. But I think in terms of to meet the clear and convincing standard laid out in the Burchell decision that they had the burden of proof on, there had to be a clear date that there's a violation of what the order was.
It doesn't have to be a date certain. I mean, maybe there's not a specific date, but you can't go for years without paying anything when you know that there is an obligation.
It wasn't that he went years for paying nothing. I think if you look at the findings, there was substantial payments made over the years. There were shortfalls on those payments, as the judge found, and then there was
As the husband acknowledged.
as he acknowledged.
Right.
But I think,
Back several years.
and I think that's where we look to what the judge, was it abuse of the judge's discretion not to find him in contempt, but clarify it, order him to pay it, and then set forward the dates that he had to pay things moving forward, or she had to pay things moving forward. And I think to say that it's an abuse of discretion to do that when the case law in this area, I think, is pretty clear that she has the authority to do that piece.
Abuse of discretion it seems to me to have two prongs. One is the application of discretion to apply discretionary principles, and the other is an error of law is always an abuse of discretion. Right?
Correct.
Okay.
And I think the law, there's case law that supports the very actions that she took.
Thank you. Thank you both.
Thank you.
We will take a brief recess. We will resume at
Yeah, so if we're sued, like if someone files a civil suit against us somewhere, those are handled by attorneys. Because they represent all the non-health agencies. But kind of our in-house things, stuff. If an employee sues us for discrimination, it has to be reported as a commission against discrimination, public relations, and all that is lame and boring.
Who's in session, please be seated.
Continue our session with an impounded matter, case number 2023 P92. This involves a termination of parental rights. I'll remind counsel that, as with all of our cases, this case, we have not closed the courtroom. The case is being live streamed on our YouTube channel and will be available for public viewing thereafter. So please, please, please refrain from any reference to names or other matters that should be the subject of the impoundment.
Yes, Your Honor. Mr. Chief Justice, Your Honors, good morning. My name is Steve Rosenthal. I represent the mother appellant in this matter, and may it please the court. It's my understanding that DCF's counsel has indicated that they will concede that in light of the recent decision in adoption of Leonard, they concede that this matter should be remanded on the issue of the expert witness testimony. It's also my understanding that counsel for the child is not conceding on that point. So I'd like to go forward with my full argument as if both parties were objecting to the appeal. I'm asking this court to vacate the order entered against mother because the trial judge failed to follow the requirements of the ICWA statute. Just last week, in this adoption of Leonard case, it's number 22P568, this court ruled that TUR in an ICWA case requires a qualified expert witness to testify that returning a child to a parent is likely to cause the child serious emotional or physical damage.
I have a question for you about, I understand from the record here that DCF had a hard time finding a qualified expert witness. Does it have to be the same witness who testifies to the must prong of what's required under CFR 23.122 as well as the should prong? You know what I mean?
No, as a matter of fact, based on case law from other jurisdictions, it's apparent that you can have more than one expert, one of whom can testify on tribal culture issues, another not necessarily qualified for the first part to testify as to the emotional or physical damage component.
Do you think the tribal cultural issues would have to be a Mashpee Wampanoag member?
Again, the case law around the country seems to say that where cultural bias is not implicated in a case, then you don't have to have an expert in Indian tribal culture. The fact that this particular expert was not from the Mashpee Wampanoag trial, I don't think was dispositive, but there were plenty of other aspects to her supposed qualifications which would render her testimony inadmissible, and the court should not have followed it.
I guess my problem, and I don't know if you can answer this or we could ever answer this, the idea that there's this additional barrier to adoption for Native American children, and as a result they're going to languish in foster care for longer, doesn't that run the risk of creating the exact problem that ICWA was meant to avoid? as far as, I'm thinking of the history of Indian schools and children being taken away from their families and their tribes. And if this is going to result in more Indian children languishing in foster care or in group homes, what do you have to say about that?
That seems to be a policy question, Your Honor, and something that apparently was or should have been discussed in Congress when the statute was passed. It should have been discussed or resolved when the Bureau of Indian Affairs promulgated regulations specifically requiring this type of testimony that I think should have been given in this case. And in any event, the Supreme Court of the United States has recently upheld the constitutionality of the ICWA statute. So, yes, it's not a perfect solution, but it's the solution that Congress came up with, and that's what we're living with.
What if the child had testified and said, here's all what my culture means to me, and I would suffer serious emotional or physical damage if I was returned to my mother, and these are the things that my pre-adoptive parents are doing to further my connection to Mashpee Wampanoag culture. Could the child be a qualified expert witness?
Not on the issue of whether she's suffering emotional damage.
Right.
And in any event, the pre-adoptive parents in this case are not members of any Indian tribe.
And they didn't testify?
They didn't testify either, no. Okay?
Can I ask a somewhat impertinent question, which is, given the age of the child, what does your client hope to accomplish by this appeal? Let's assume, for the sake of argument, that we accept the concession that this has to go back. The child is almost 16. She's at an age where she largely, under the law, gets to determine her own fate. In 2 years, she will, as a matter of law, be able to determine her own fate. The remand proceedings are going to take some time. What is your client seeking to accomplish?
Well, first of all, besides what my client would have to say, the statute is there for a reason. The rules are there for a reason. DCF had an obligation to meet its standard of proof. It didn't do that. This is no different than any other case, whether it be a contract or tort or a crime, where certain elements have to be proven. And those elements, or not all of those elements, were proven in this particular case. Now, as far as what my client hopes to accomplish in this case, she wants to be able to have a parent-child relationship with this child. She has, as a matter of fact, the trial judge at one point asked counsel for mother, what does she want to do? And
in 2 years, she can have whatever relationship she and the child want, regardless of how this case comes out, correct?
That's true, but that's no reason to overlook the requirements of the ICWA statute. They're there for a reason. What my client would hope to do is have this matter remanded, and you have to understand that this case was tried, the trial ended in August of 2021. So, and that, much of that evidence was stale even then because this case has been going on for so long. Now, it's more than 2 years later. It'll probably be about 2.5 years by the time this case comes back for another trial, and mother should have the opportunity to contest the issue of her fitness or unfitness since August of 2021. If I may continue. I want to emphasize that the case before you is even stronger on this particular issue than in the Leonard case. The same witness, the same exact person, testified in both Leonard and in this case. And the trial judge in this case explicitly ruled, as was not the case in the Leonard case, explicitly ruled that at transcript page 319, that this witness was not qualified to state psychological conclusions. Over mother's objection, the witness then gave a watered-down answer. Instead of stating whether there was a likelihood of serious emotional damage to the child, she said only that there was a risk of substantial emotional harm. A risk, not a likelihood. A substantial harm, not serious damage. That's not a matter of semantics. That's DCF's burden of proof, which it did not meet. The judge then used the witness's exact words at finding of fact 585 to justify the TPR, the termination of parental rights. This witness's testimony was inadmissible here for the same reasons that it was rejected in Leonard at page 15 of that decision. It lacked the necessary foundation to predict the likelihood of harm to the child. In this case, when this witness testified, she admitted she's not a psychologist or a psychiatrist. She's never even met this child. She hasn't met the therapist. She hasn't met any of the child's collaterals, and her review of the file consisted of 40 pages culled from a 12-year record. The witness's testimony basically fails for 3 reasons. 1, the judge ruled that she was unqualified to state psychological conclusions, then she went ahead and stated one anyway. 2, she lacked sufficient facts, even to form an opinion. And 3, her statement that there was a risk of substantial harm did not meet the ICWA standard of proof. I'd also like to point out the 16-month delay in issuing findings of fact in this case prejudiced mother. It's hard to think of a better example of prejudice than in this case. In finding of fact 585, the judge quoted this unqualified witness's testimony word for word. The child was at risk of substantial emotional harm. That's a psychological conclusion. When the trial judge finally issued her findings, as I said, 16 months after the trial ended, she'd apparently forgotten that she'd already ruled that the witness wasn't qualified to draw psychological conclusions. And that testimony led or at least contributed to the TPR. The long delay between the trial and the findings caused or contributed to the judge's clearly erroneous finding.
But for the statutory and regulatory overlay, it would be permissible, it seems to me, as an intellectual exercise, for a judge to conduct that evaluation of whether the child would experience serious harm without expert testimony. Correct?
I don't believe that is correct, Mr. Chief Justice. The case law throughout the country and now from Leonard specifically says...
I said setting aside the statutory and regulatory overlay, if not for ICWA, it seems to me that the assessment of the likelihood of harm is of a piece with the kinds of evaluations that juvenile court judges in these cases are called upon to make all the time.
But if this were a garden variety care and protection case, I would agree with you.
And so the entirety of this issue rises and falls on whether the expert in this case satisfied the evidentiary requirements imposed by ICWA and the regulations promulgated related thereto.
I would phrase it differently, Your Honor, with all due respect. Number 1, she wasn't qualified, and the judge determined that she wasn't qualified. And number 2, she did not testify to the standard as required under the statute.
I understand.
And I don't want to get too far into the weeds here, but in my remaining time, I'd like to point out that even if this witness were qualified, her opinion was based on speculation that mother might expose this child to her son, who had allegedly molested child's sister way back in 2008. That's what precipitated this petition. That was never proven. I direct your attention to Appendix Volume 2, page 15. There, the court-appointed investigator reported that the initial 51A was supported not due to sexual abuse by the son, but for other reasons. See also Appendix Volume 1, pages 168 and 69, and you can see the judge's summary found at mother's addendum to her brief at page 47. An SAID interview with the sister supposedly took place in January 2009, but there's no report of what was said or what conclusions were drawn. The sister alleged sexual abuse by the son a second time in 2016, despite the fact that she hadn't lived with this brother, her brother, for about 5 years. That claim was unsupported after an SAIN investigation found in the appendix volume 2, pages 56 to 61. Despite all that, the witness claimed this was the main reason child was at risk for substantial harm. I'm quoting from transcript page 320, deleting the names. Given that mother has not remedied the situation and has continued to maintain a relationship with the son and exposed child's sister to the son, there is a substantial risk to child as well. DCF failed to prove this subsidiary fact by a preponderance of the evidence, so its concern about the son doesn't justify a finding beyond a reasonable doubt that this child was likely to suffer serious emotional damage. For these reasons, and for those stated in Mother's principal and reply briefs, I ask that this matter be, that the judgment against Mother be vacated and the matter remanded. Based on what is in, what's in the Leonard case, it would seem to me that one of three things can happen. Either the petition would be dismissed because DCF didn't prove its case, or the matter would be reopened for evidence to determine Mother's current fitness. Current fitness from the end of the trial in August 2021 to the present. If there are no other questions, I rest on my briefs.
Thank you.
Thank you, Your Honors.
Mr. Bayless, according to the bench slip, you propose to use 10 minutes and leave 5 minutes for child's counsel. Was that allocation determined before the concession that we were advised you'll be making?
It was, Your Honor, and with the permission of the court, I would move to an even split, because I know my sister has much to say. May it please the court, Jeremy Bayless for the Department of Children and Families. Since the briefing in this case, there has been an above-average amount of intervening case law on the issue of ICWA. It was upheld by the Supreme Court in the Holland decision, and its requirements in the Commonwealth of Massachusetts were clarified by this court in the Leonard decision. Of particular note, this court held that the regulations promulgated by the Bureau of Indian Affairs, which require that qualified expert witnesses must be qualified to testify to sort of the continued risk of the likelihood of serious damage maintained in the parent's custody, are enforced, that we look to those instead of the plain language of the statute. Because of that change, the department is must therefore agree that this expert witness did not meet the requirements in those regulations and that it remand.
It's one thing to have authority that clearly speaks to a general principle, but in this case, it's speaking not simply to the principle, but the identity of the individual witness that's involved.
It's hard to imagine a case that would be more on the
Squarely
nose.
on point.
Yes, which is why
I'm sure we'll hear something more about that in a few minutes.
Yes. So the department would ask, though, that in the event, presuming that this court is inclined to agree that Leonard controls, that a remand on the issue of the qualified expert witness testimony is ordered, that every possible effort to expedite those proceedings be made, if it's possible.
We try to move these cases along as promptly as possible. It has been a personal effort of mine throughout my career on this court.
I have a question on the 1 versus 2 witness issue in construing the federal regs. There has to be testimony about, there must be, a qualified expert must be qualified to testify about whether continued custody was likely to result in serious or emotional or physical damage, and should be qualified to testify about the prevailing social and cultural norms. I understand the Mother's Council has said that can be 2 different witnesses. There also has to be this testimony about a causal relationship between the conditions in the home and the likelihood of that serious emotional harm, and that if the conditions in the home show only poverty, substance abuse, inadequate housing or nonconforming social behavior, that's not by itself clear and convincing evidence. So could one expert, does it have to be one expert that can testify to that nexus? Or could you have, say, a typical Caucasian therapist testifying to the expertise on the harm and someone else talking about the conditions and the cultural aspects? How would they?
So, Your Honor, I think there's a lot of leeway there. It certainly is not the case that one person has to do all of it. The statute itself, it is including the testimony of qualified expert witnesses. So it's contemplating multiple. Also, there are circumstances where there are tribes that do not agree with the termination of parental rights as a concept and will not cooperate. And so there has to be an interpretation of the statute that would allow proceedings in the event that, that the tribe just won't engage. So I think the best way to sort of synchronize all of that is that there, in an ideal world, as some tribes have, there will be a tribal representative with the requisite qualifications to satisfy the clinical piece, if you will, and they can do it all. If that isn't possible, then it would be acceptable under ICWA to have one expert of any background who is qualified to testify to the likelihood of damage piece.
So like an academic anthropologist who's not a member of the tribe?
No, I'm sorry. I'm actually talking about the psychologist, psychiatrist,
Okay.
social work, that piece. And then the regs say must and should, so I don't agree that every case would require an expert on sort of the cultural piece, but that can be satisfied by a separate expert from the first. They could be an academic. They could be a tribal leader. There's any number of backgrounds that could fulfill that, but that they can be done separately.
As a practical matter, I'm guessing that there is not an enormous number of professionals who are available to provide this kind of expert testimony.
Which part are you referring to?
The tribal impacts?
Yes, that is accurate. And actually, this transcript in this case kind of came about in a perfect storm, where in the transcript, our attorney on several occasions laid out the difficulties the department had. Multiple experts fell through. There were issues with the Mashpee Wampanoag tribe, where their leadership was not in a very functional state at that time. That kind of led to
like a systemic problem in need of a systemic solution to some extent. And while I realize that these cases are likely a relatively small subcategory of those that the department is involved with, it seems to me it would be, I understand also that the department is chronically resource challenged, but this seems to me to be an appropriate area to invest some effort to try to address that systemic challenge.
I actually think that, because as Your Honor is well aware, in Massachusetts we have been working with one published decision on the Indian Child Welfare Act, and that decision was made over 20 years ago. The decision in Leonard clarifying what needs to happen for these cases will be of great assistance going forward. It unfortunately happened after this case.
Well, and I understand that there's been very limited time for you to react. I'm not asking you to defend the fact that it hasn't been fixed yet, but
I'm sorry, I didn't mean to cut you off.
So I'm just making that observation that it seems to me that it would be an important area to address moving forward.
And there are more experts available to testify to the clinical piece, to the fact that whether or not the facts in a case rise to the heightened standard that ICWA requires. And simply, it will simply require work going forward to find the experts on the other piece.
Thank you. Why don't we hear from counsel for the child?
Thank you, Your Honor.
Please support Adriana
Cortese. I'm eager to hear how you're going to explain that Leonard doesn't control this case.
I have a client who is very motivated to encourage the court to find a way for this case to hold and find that Leonard was
I understand
too
and
narrowly
anticipated
construed.
that request in terms of the outcome. I was more interested in how you propose to help us do that.
Well, I have two things. I think that there was plenty of evidence, some of it that didn't even need an expert, and that was one of the questions asked in Leonard. Do you always need an expert witness to testify to mental or physical harm? Well, I don't think so.
Doesn't Leonard say that?
Well, that was a question that the court asked during the Leonard argument. I listened to it.
But the Leonard opinion came down with an answer to that, and, that may not be the answer that you were hoping for, but it is what it is.
In this case, there was evidence. First of all, my mother, in this case, conceded in her brief at page 36 that being shunted to 18 different residences in like the first, I think, 3 or 4 years of her life, 18 different residences may have caused her emotional harm. I don't think anybody needs to be an expert to be able to opine that having been shunted around, accepted and then rejected, accepted and
I understand
18
that,
times.
but you heard my exchange with Mr. Rosenthal. But for the statutory overlay, this type of evaluation, this type of assessment, this type of conclusion would be squarely within the scope and range of the kinds of things that juvenile court judges do all the time. And all of that evidence that you're pointing to would tend to support that conclusion. We are not operating, however, in that vacuum. We have a statute that we have, from this court, recently concluded requires qualified expert testimony. Leonard concluded that this expert was not qualified. The judge in this case actually agreed with that before Leonard came down. And therefore, we are not operating in a setting that allows us to ignore the statutory requirement.
Well, the court only concluded that the expert was not qualified to opine on psychological matters, but that left out whether or not the expert was permitted to opine on physical matters. And again, do you need an expert to draw the causal connection between the fact that this mother allowed her son to continue living in the house with her after the older sister made credible allegations, long-standing credible allegations of sexual abuse? It's on record that the mother told the older daughter, listen, shut up. If you don't shut up about this, you're not going to be able to come back and live here. It was on the record that in 2021, this boy was still living in the mother's house. So when our qualified expert in Indian affairs gave an opinion based on that evidence that was in evidence that it would put this client it would expose her to a risk of physical harm, which is sexual abuse.
But
I don't think you need an expert
Even accepting that,
Yes,
wouldn't it still have to go back for the judge to assess whether there was a likelihood of physical harm as opposed to being at risk of physical harm?
No, it doesn't, because at risk and a likelihood, it's semantics that are really meaningless and results in a very narrow decision that does not comport with the entire purpose of ICWA, which specifically is not to be prejudiced against Indian parents. So in this case, there was no prejudice. The opinions coming from the qualified expert were reasonable opinions. She had her own background in Indian affairs. There is no harm or no chance that there is any bias in that opinion. It's a common sense, basic.
I understand your frustration, but this would not be the first instance in which a statute, the implementation of a statute did not, in fact, operated at cross purposes with its apparent objective.
I wanted to say it's important to me that you're here today to express your client's point of view. I hear your client's point of view. I'm glad that she's doing as well as she is, and every day she's getting older. And it's good that she is continuing her affiliation with her tribal culture. And I'm glad that you were here to express her views, and I hear her views.
Well, she's tribal culture. She's much more interested in moving her own life along and being adopted into this wonderful family where she has lived for such a long time, which has been a haven to her. So again, she just would ask the court to stand up for the fact that emotional damage is on the record, beyond a reasonable doubt, conceded to by the mother as a result of the 18 different foster homes this little kid had to go. It's on the record that she was crying in the back seat of the social worker's car, saying, "Why am I moving around while my mother sits on the couch and smokes cigarettes?" The mother didn't want the kid to go on a nice vacation to Maine, but she went to Portugal with her husband. There's plenty of evidence in this case that came in. So based on that, the expert witness could give a lay opinion on that would create that evidence of beyond a reasonable doubt so that this court could stand up for this termination. Now, if the court feels constrained that they can't do that, even if they did it in an unpublished decision, I would ask that the court make an expedited order on this decision, ordering an expedited remand, giving a very limited narrow of time for that additional testimony to come in, just on that very narrow issue.
Thank you.
Thank you.
Thank you. Thank you for the courtesy.
We reached now the final case on our hearing list today. This case is a matter that was originally scheduled to be argued at our session down at UMass Law School on Monday. It was moved to today's hearing list. It's case number 2022 P825. It's criminal matter Commonwealth versus ELANA Gordon.
Oh, yeah. Fair enough. All right, may it please the court, Christopher DeMeo for ELANA Gordon. So we have 4 issues today. I'm going to touch very briefly on the first and the third evidentiary issues, which I think are pretty straightforward. The first is about the calls. The panel has heard them. They're sort of self-evidently inflammatory. We don't think there's a lot of probative value, particularly on the first longer one where there's not even a discussion of paperwork or anything of that sort. So that's really all there is to that. The third issue is about the phone. There's nothing on the phone, and that was supposed to be the relevance, is that there's nothing on the phone. So the prosecutor said, I'm going to make a point of that, and that in theory that makes some sense. If the phone has nothing on it, one might confer that it had been wiped out of consciousness of guilt.
Did anyone ever use the word wiped in front of the jury?
No, I don't think so. I don't know if it was wiped or reset. There's definitely talk about resetting the phone remotely or wiping the phone remotely, which I suppose most jury members would already know about. But in order to get this to be relevant, to have some foundation of relevance, there needed to be some foundation that not just anyone, but Ms. Gordon in particular, could have wiped the phone. And there was the opposite of that. There was testimony that it's put into airplane mode as soon as it's seized, and that it was quickly, within a day or two, extracted, and that she was in jail for at least part of that time until she...
So if the Commonwealth had been barred from introducing evidence of the search of the phone as unduly prejudicial, would the defendant have been entitled to get up in closing and argue that the police didn't do a thorough job because they didn't search the phone?
No, I mean, I think there's plenty of case law saying you can't, and this goes for the defense as well as the Commonwealth, you can't make hay out of something when you're the one who moved to have it suppressed or who moved to keep it out in limine. So it'd be that same principle there.
I remember the, I'm sorry, I read this case in anticipation of hearing on Monday, and so I don't recall this specific detail. When this came up at trial, was there an objection to the foundation?
The objection was really, the objection was made in limine. And it's a peculiar situation because it seems like the only people here who would actually, no, I'm sorry, I'm thinking about the phone calls now. The objection, I believe it was made in limine.
But quite apart from the objection in limine, when the evidence was offered at trial, there needed to be a foundation for its admission, right?
That's true.
What was the, there are two layers here. One is relevance and the other is foundation. Yeah. And what I'm trying to understand is what was the exchange concerning the foundation, the argument that you're making here, either in limine or at trial?
I thought the in limine argument was just that if there's nothing on it, it's not relevant. And so
what do we do with the fact that that in limine argument happened at the motion to suppress the phone before a different judge? I think it was Judge Moriarty, and the trial happened before Judge McGuire. Did that preserve the issue under Grady?
As far as I know, it would have been a better practice. I agree with you. It wouldn't have hurt for the trial counsel to say what I'm saying here, but he didn't. But as far as I know, that the whole point of the Brady was to eliminate having to bring up previously litigated evidentiary issues. So that's basically the argument there, and it's. So it came in, it wasn't relevant, but the fact that it's not relevant doesn't mean it's not prejudicial because it has this kind of insinuating quality that we powered it up and it had, it had been wiped or reset, or so it makes you think, well, why was that? But there's really, the government didn't do its job proving Ms. Gordon could have done that.
I guess what's holding me up a little bit is that if the Commonwealth were not challenged at the presentation of this evidence at trial to lay a more complete foundation, it seems to me that circumstantially it would be a permissible inference that the defendant, whose phone it was the person responsible either directly or indirectly.
Well, it's quite a stretch of an inference, it seems to me.
I understand, but in the absence of an objection or in the absence of a challenge to do something more,
yeah,
I have a hard time getting to substantial risk of miscarriage of justice.
Yeah, well, I'm taking it in combination with various other things, but the inference has to be that even though it's their practice to put it in airplane mode, they didn't do it here, and somehow, while she was in jail, she managed to reset it. So we think that was.
Or managed to have some. Yeah. There are lots of possibilities, but this didn't just magically occur. Someone took an action, and in the universe of potential protagonists, there's a lot of circumstantial issue that would point
the main. I want to have some time to talk about the prison rules and the leaving of things with prisoners. So the issue here is the prosecutor said, I'm going to use the violation of prison rules to show that, this was an intent to smuggle, which is in theory a possible something you could do. But the problem here is, and what made this unfair and prejudicial and misleading, we would submit, is clearly there's a Sixth Amendment. A lawyer visitor to a prisoner does not stand in the same shoes as any other.
But how would it have helped your client for trial counsel to have brought that to the jury's attention? I understand the guards mistakenly testified that lawyers were not allowed to leave documents with clients. They had to mail them.
Yes.
When in fact the regs say lawyers may leave documents with clients, but they're subject to search.
Yes.
Either way, where your client's defense at trial was, she didn't know there were drugs in the envelope.
Well, it makes a huge difference. I mean, yes, the defense is I did a dumb thing here. I had somebody else print the stuff, and that's what I showed the client. And you know, that would have been the defense, and that's fine as far as it goes. But instead, what she tried to do, I should have mentioned Ms. Gordon is in the courtroom today, but she took the stand, as the court knows, and she said, all lawyers do this, and I'm going to try and not go outside the record here, but I feel like I'd be remiss if I didn't say yes. All lawyers leave things at jails and prisons, and I showed it to that guard there that you can see.
But wouldn't that add to the Commonwealth's proof or their theory that the people involved in this conspiracy with her picked her to bring this envelope into prison because she was a lawyer and she could get it in?
Well, they're gonna. I mean, that's the theory, no matter what. But what was terrible here is Ms. Gordon took the stand and said, "I showed it to her like I always do." And if we had just been bound by the Exhibit 1, which is at page 15, which says that's exactly what you can do, then we would just have we'd have a factual dispute. You know, and trial counsel could have said, "Well, you heard from her, and we'd submit." You heard from the correctional officer, she just didn't remember what happened 3 years ago, and we'd ask you to credit Ms. Gordon, who testified that she's done this before, and that's exactly what she did. Instead, there's this testimony that she couldn't have done that. It's not a matter of the correctional officer remembering what happened that day. It never happens. It's forbidden. That was the quote they used. It's forbidden. And then, I mean, that was still bad. I mean, perhaps trial counsel could have skillfully dealt with that by saying, well, you could have soft-pedaled that and said, we still ask you to credit Ms. Gordon. But really, the salt in the wounds, he got up and said, you're not supposed to give anything to an inmate. You don't do it. Da, da, da. It's wrong. It's stupid. There's reasons why it doesn't exist. The Commonwealth's witnesses have established that for you. This is after she just testified. I showed the envelope to the woman. You can see me in the video. She flips through it. This is what I do. This is what lawyers do. He just heard her. I don't know. There's no conceivable strategic reason for that. I would submit it was completely unreasonable, and it took a bad situation and made it just much, much worse because the whole case turned on the Commonwealth, the jury believing that this was a stupid but innocent mistake that she made, and here's the lawyer saying, well... Sorry,
did you raise a claim of ineffective assistance?
I didn't. I'm saying it's manifestly. I'm linking this together with the testimony about...
You're jumping around a little bit more than I'm accustomed to. I'm sorry. I'm having a little bit of trouble following the thread of your argument.
The thread of my argument is the testimony about unwritten practices that lawyers don't leave papers, which is completely untrue, shouldn't have come in. It was unobjected to, so it's substantial risk, all right? But it shouldn't have, it's untrue, it's misleading, it's prejudicial, it's confusing. And then the damage, which might have otherwise been mitigated, was instead of being mitigated, what I just read you is really kind of the salt in the wounds. It's like...
What do we do with the fact that your client testified that she didn't represent the guy she gave the papers to? So that sort of undermines the whole argument that there was some prejudice flowing from this mistake about whether or not a lawyer would be entitled to give papers to a client.
Well, I think you're entitled to go meet a potential client for the first time. It seems to me a case like this shouldn't turn on nice points of legal ethics and when is she retained as his lawyer and things. She showed up, she'd been told there's this guy who's looking for a lawyer who she might be able to represent, and that seems to me to be totally appropriate. But I don't know how you can get around the prejudice from this testimony that you can't ever leave things with prisoners, and then this defense counsel saying you can't ever leave things with prisoners, and this was a terrible thing she did when she just testified that I showed it to them and I thought it was cool and I went in. I mean, that's the equivalent of saying I don't believe what my client just testified a few minutes ago.
Again, you didn't raise a claim of ineffective assistance, so I'm having a very difficult time seeing where you're going with this.
I'm going with the prejudice that flows from. Prejudice is still part of substantial risk of a miscarriage of justice. There's prejudice from people saying falsely that lawyers can't leave papers with prisoners here.
Well, the falsity of that statement is based on your representation here at the podium for the first time, that this is, I don't see an evidentiary basis for that in this record or elsewhere.
I cited regulate. I mean, it's as a matter of law, it's done every day in dock facilities, and I also cited regulations in the reply brief that say what the rules that there need to be written policies in place, and that's what we have. All we have is this Exhibit 1. So when they tried to walk away from this and said, no, you actually can't leave anything with anyone, not even if it's the officer in charge, it was completely inappropriate. I just have 2 minutes left to talk about the analyst. I'm not going to talk at all about confrontation. That was for the SJC, and they didn't take this case. I do want to talk about the buprenorphine. It's not a Class B. This is not objected to, so this is certainly a substantial risk. It's not in the statute. It's not a Class B drug. This court would have to find, I believe, that it's an opiate, which is defined in terms of something. I'm going to quote it. I think it's substance having an addiction-forming or sustaining liability similar to morphine. Clearly, Suboxone has something to do with opiates because it's used, to treat drug addicts.
Again, was this the subject of an objection at trial?
No, this was not. This didn't come up at all at trial.
Okay, and so what you're asking us to do is to reach the conclusion that the expert wasn't qualified to give an opinion that the expert gave in the absence of a challenge to her expertise at a time when that expertise could have been probed as an evidentiary matter.
That's exactly what I'm asking you to do.
Okay, that's what I thought.
Yeah,
Thank you.
because she's clear. This is not something this court can take judicial notice of. That while there is no substantial.
In the absence of an objection, we're not going to assume that the result of that inquiry would be as you suggested would be.
I mean, if it's a matter of taking judicial notice, I would suggest.
It's not a matter of judicial notice.
I would submit you can't.
It's not in any close universe to judicial notice.
Yeah,
So
exactly.
The analyst testified at volume 4, page 35, without objection, that buprenorphine is a Class B substance.
Yes.
And you're asking us to take judicial notice of something saying it's not?
No, I'm asking you to look at the statute. It's not there. Unless.
No, but you're also asking us to conclude that the expert was not competent to offer that opinion.
Yes, I mean, I am.
In the absence of an evidentiary basis. Thank you.
She was qualified to identify
We'll hear from the
drugs.
counsel for the Commonwealth now.
Good afternoon, Your Honors. If it may please the Court, Arne Hansen for the Commonwealth. With respect to whether or not the jail calls were properly admitted, the defendant argues that they're probably not admitted, or they shouldn't have been admitted because they're either inflammatory or prior bad acts without citing why they were inflammatory or prior bad acts. They're certainly not inflammatory. I haven't found any case law that suggests that the use of profanity would convert evidence into inflammatory evidence. A review of the case law in this section really deals with a lot with murder cases, photos of bodies, et cetera, and how much blood you can show from a crime scene to a jury without setting them off emotionally. And with respect to prior bad acts, again, this is not a prior bad act. Prior bad acts is again reviewed in the context of uncharged criminal conduct, as well as prior conduct that a defendant may have been convicted for. Again, he or she is just swearing during a phone call where she's clearly planning delivering these substances to the jail with the individuals involved. From the phone call, it becomes clear that inmate Costello is organizing it from within. He has his sister get the Suboxone. Yes, the drugs are never mentioned, but he gets the sister to get the envelope, which ultimately contains Suboxone, deliver that to the attorney, who was then going to meet with another inmate that she did not know, inmate Bell, and Bell would then transfer that envelope back to Costello. So certainly it's even if it's considered prior bad acts, which the Commonwealth is not conceding that it is, and I don't see any reason.
What do you say in response to the challenge to the evidence about wiping the cell phone?
With respect to that, Your Honor, it's certainly, it's a relevance issue, and that's a very low bar, and that would have been.
What about the foundation?
The officer testified that he did this for a living. He testified specifically that when he received the phone, he turned it on and found that it had either been reset or never set up in the first place. There was testimony that this could have been done remotely, and that would have been based on his experience with the Celebrite software, which he also discussed.
And no objection.
That is correct. So where there was no objective, there was no real prejudice, and it certainly was. Again, the threshold is very low, but it's certainly relevant because you would expect potential evidence of other communications with this defendant and the other individuals involved to set up the exchange of that envelope. And that being said, it was never used as consciousness of guilt evidence, though it could have been, but it was never mentioned either in opening or closing, so it seems like a very small point in a trial where there was overwhelming evidence already. Does the court have any questions for me that I can address specifically, rather than me going through my entire brief?
We have the arguments in your brief as well as the arguments in the defendant's brief. We will, if you have nothing further to say, I think I'm good on questions.
The Commonwealth rests on its brief. Thank you.
Thank you both. That concludes our argument session today. We are adjourned.
Thank you.